Hello, I'm John Vanderloo, Editor and Employment Lawyer, and thank you for joining today's webinar on how to navigate overseas remote working requests. Employers are facing more and more requests from employees who want to work remotely and abroad, both in the short and long terms. While employers are generally sympathetic to such requests, there are challenges in doing so. Today we are joined by a panel of experts from Lewis Silkin to discuss some of these challenges and how employers can minimise risk to their businesses. As always, before we get started, there are a few housekeeping points to cover. First, please use the online question tool to post any questions you might have for our panel, and I will share them with the speakers during the Q&A session at the end of their presentation. Second, if you have any audio-visual problems, then please use the online question tool again, and a member of the team will be on hand to support you. Finally, just note that today's session is being recorded, and we will share a copy of the recording via email and on IEL in the coming days. Now for the introductions. Victoria Good is a consultant partner at Lewis Silkin and a go-to for all things tax and remuneration. She has written the practical law practice notes on the remuneration code of banks, building societies and investment firms, and the AIFM remuneration code for alternative investment fund managers. Supinder Singh recently joined Lewis Silkin from Squire Patton Boggs, where he was a partner in the immigration team for 8 years. He deals with all areas of UK business, sport, high net worth immigration, and global mobility coordination, and has particular expertise in international agreement, contractual service, supplier sponsorship. Next, we have Colin Leckie, who is a partner at Lewis Silkin for nearly a decade, specialising in employment law. He has particular focus on financial services, professional services, and technology, and was voted Lexology Client Choice UK Employment Lawyer of the Year in 2020 by In-House Counsel. Next, we have Linda Hines. He is a partner in the Dublin office, dealing with Irish employment, immigration, and data protection matters. She advises multinationals on changes to terms and conditions, unfair dismissals, payment and wages claims, restructuring, and transfer of undertakings. And finally, but by no means least, we have Rosie Moore, who is an associate at the firm, providing advice on contentious and non-contentious employment law issues. Her experience includes supporting employers in relation to disciplinaries, grievances, dismissals, redundancies, and 2B transfers. Thank you all for joining us today. And without further ado, I'll hand over to Colin to begin the presentation.
Thanks, John. Well, given today's topic, I'm finding it somewhat ironic that I'm broadcasting to you from what is essentially a cupboard in the Lewis Silkin London office. So I personally am clearly not taking full opportunity of all of the new advantages that are out there for us in the modern world of work. This is unquestionably, no doubt for everybody on this call, a very hot topic for all of us who advise on international employment law issues. We'll have spent much of the last 18 months advising on all things to do with the shift to remote working, whether that's health and safety or mental health issues or flexible working requests. Well, requests to work from remote working locations in a jurisdiction other than the employee's home country contain with them all of those issues and many more besides. John, I don't know if I can get your technical assistance. I'm trying to move the slides forward, but unfortunately it doesn't seem to be happening at my end. I don't know if that's something that somebody else can move us on to the next slide. But what we'll be covering today in this session is sort of all of the key legal considerations that you need to bear in mind when you're advising your businesses on whether to accept these requests or not, as well as looking at some of the practical tips, the policies that you can put in place, the side agreements that you can enter into with employees that might help you to minimize some of the legal risks. What you should have in front of you, but unfortunately I don't think you do at the moment, is a slide that just sort of summarizes some of the key statistics that just shows what a significant issue this is in the world at the moment. We have some statistics from the UK from June 2021, the Office for National Statistics, which showed that online job adverts that included terms relating to home working in May 2021 were 3 times higher than they were back in February 2020. And of UK adults who are currently home working, 85% want to use a hybrid approach to both home and office working in the future. So we all know that remote working is here to stay, and we can all expect that, given that we have a global diverse workforce, that a significant component of that is going to involve requests to work from an overseas location. And the difficulty that we all face here is that the law really hasn't caught up with this yet. And what this is really calling out for is an international legal framework that is entered into by multiple countries, addressing all of the tax, employment law, social security, immigration, and other headaches that go along with dealing with these sorts of requests. But there's no sign of that on the horizon at the moment, nor frankly is there likely to be anytime soon. And while one or two go-ahead jurisdictions, and Barbados and Dubai are particular examples of this, have created schemes encouraging employees to work there remotely and spend their money in the local economy, and have to some extent solved the problems that employers grapple with when they consider these sorts of requests. The overwhelming majority of countries of the world have not taken such an approach, which means that you always need to look on a case-by-case, jurisdiction-by-jurisdiction basis at what the risks are with agreeing to any particular request, and decide what approach you're going to take to them. So we're going to look at the key issues for employers when considering requests to work from home, and top tips for them to minimise those risks. So what we'll be covering is, from an immigration perspective, we'll be looking at whether employees can legally work from the host country that they want to go to or not, and what issues might arise when and if the employees want to return to work or are called upon to work to their home location. We'll be looking at tax and social security issues, which are quite critical here. So what are the employer's continuing obligations in the home location? To what extent will the employee's stay create a risk of an income tax or social security liability, or a withholding obligation in the host of country? We'll look at the particularly important question of whether there's a risk of creating a permanent establishment, and what are the pitfalls if you were to do that. And we'll be looking at a wide range of other considerations. So, for example, will the employee start to benefit from local mandatory employment protection, so the right to sue you for unfair dismissal or the relevant equivalent in the country in which they've chosen to go and work from? What will be the impact on some of the benefits that they're entitled to as part of their employment contract? We'll look at the use of so-called employers of record or professional employers organisation. But is that a solution to this problem? How far should you go in making use of these sorts of organisations, and what are some of the pitfalls and challenges there? And what should you do in order to document the arrangement? What are issues like health and safety and quarantine requirements and data transfers? So that's the outline for the session. I'm going to now hand over to Victoria, who's going to talk to you about the tax and social security issues.
Thanks very much, Colin. Before looking at the issues outlined by Colin in more detail, it's important to note that the length of the employee's stay or stays in the host country is a critical factor in determining the tax position. Generally, the greater the length of time the employee spends in the host country, the more likely it is that tax or social security issues will arise in that country. Subject to local advice, stays of up to a month are likely to be relatively low risk, provided that the employee's stay doesn't form part of a more substantial period of presence of the employee in that country. On the other hand, however, stays of 6 months or more will definitely create tax issues in the host country. Looking first at the employee's income tax position, the starting point is that the employee is subject to income tax on their employment earnings in the country in which they physically carry out their duties. This means that potentially there is an income tax liability in the host country on the income the employee earns whilst working there. However, if there is a double tax treaty between the host country and home country, and a number of conditions set out in that treaty are satisfied, the employee will be exempt from income tax in the host country. It does depend on the particular treaty, but generally there are 4 main conditions that need to be satisfied before the employee can benefit from the tax exemption in the treaty. And those conditions are, firstly, that the employee remains tax resident in the home country. If the employee is also tax resident in the host country, which will be determined in accordance with the law of the host country, then the employee's tax resident status is determined in accordance with a series of tiebreaker tests set out in the relevant treaty. And those tests look at the country or countries in which the employee has a permanent home available to them, the country in which the employee's centre of vital interest lie, the country in which the employee has an habitual abode, and finally the country in which of which the employee is a national. The second condition that needs to be satisfied is that the employee must not be present in the host country for more than 183 days in any 12-month period. This test requires you to look at any day or part day that the employee is present in that country. So it includes days of arrival and days of departure, and it includes not only working days, but also holidays and weekends. How the 12-month period is calculated varies from treaty to treaty. For example, it could be based simply on the tax year or any 12-month rolling period, or in some cases, it's actually based on any 12-month period that begins or ends in the relevant tax year. The third condition that needs to be satisfied is that the employee must not be paid by or on behalf of an entity based in the host country. And finally, that the employer must not have a permanent establishment in the host country. And we'll come on to look at what that means shortly. If one of these conditions isn't satisfied, the employee will be liable to tax in the host country. In addition, if the employee has remained tax resident in their home country, they're likely to also be subject to tax in the home country on their worldwide income, although in calculating their home country liability, they should get credit or relief for the tax they pay in the host country. The second issue to consider is whether the employer has any obligation to withhold income tax from the employee's salary in the home and or host countries during the period the employee is working abroad. If the home country imposes a withholding obligation, there is likely to be a continuing obligation to withhold income tax in the home country, notwithstanding that the employee is working abroad. In the UK, for example, if an employee works from abroad, income tax must still be deducted under the pay-as-you-earn system unless the employee is going to be working abroad for a complete tax year and prior authorization from the UK tax authorities has been obtained. There may also be an obligation to register as an employer or withhold income tax in the host country, and this would need to be verified with local advisors. The third issue to consider is social security. Unfortunately, the social security rules are completely different from the tax rules. So, for example, there is no equivalent to the 183-day test, and you're looking at a completely different set of international agreements. Again, the general rule is that employer and employee social security is due in the country in which the employee is physically working. Under the social security agreements, there are exceptions to that general rule, where the employee and employer can continue to pay social security in the employee's home country. In particular, where the employee is on secondment for a specified period of time, ranging from 12 months to 5 years, depending on the country involved. In some cases, principally for the EU and EEA countries, there is also an exception where an employee is working in 2 or more countries, where generally the employee can remain within their home country's social security system, provided that they are spending at least 25% of their working time in their home country, and their home country is their country of habitual residence. Advice is needed on a case-by-case basis as to whether any of the exemptions applies. For example, it's not clear that where an employee has requested to work abroad for personal reasons, rather than being sent by the business for business reasons, that any secondment agreement, that any secondment exemption would apply. And the approach varies really from country to country. If an exemption under a social security agreement applies, it's important to obtain a certificate of coverage from the relevant social security authorities confirming the position. In addition to looking at the position under the international social security agreements, it's also worth considering the position under the host country laws, as host country laws may contain other exemptions. For example, under UK law, employees sent on secondment from those countries with which the UK does not have a social security agreement can be exempt from social security for the first 52 weeks of working in the UK. The final issue to consider from a tax perspective is whether the employee's presence or activities in the host country create a permanent establishment for the employer in the host country. This is an important issue since any profits attributable to the permanent establishment will be subject to corporate tax in the host country. And as we have seen, it's also likely to result in an income tax liability for the employee in the host country and potentially a withholding obligation for the employer. Again, it depends on the host country rules, but generally under the double taxation treaties, a permanent establishment is created in one of two ways. The first is if the employer has a fixed place of business at its disposal in the host country through which its business is carried on. This includes a branch or a place of management, but does not include a subsidiary. The second way in which a permanent establishment can be created is if the employee has and habitually exercises an authority to conclude contracts in the name of the employer. This will be the case if essentially the employee is negotiating the main terms of contracts with customers, which are then adopted by the employer without any significant amendment. As I've mentioned, a relevant factor is the length of time the employee spends in the country. While stays of under 6 months are unlikely to have the required degree of permanence to create a permanent establishment, stays of 6 months or more will need to be considered extremely carefully. So that's a very quick summary of the tax and social security position. And it now gives me great pleasure to hand over to Supinder to take us through some of the immigration issues.
Thank you, Victoria. As Victoria was mentioning, there's so many complexities with what we're discussing today. So quite generically, to talk about immigration, what does remote working mean from an immigration perspective? It's absolutely critical as the employer that you're assessing whether your employee has the legal right to work in that host country. Now, if they're a national of that host country, that will be absolutely fine and you have no immigration issue at all, but there will be other immigration issues such as what Victoria has discussed and my colleagues will discuss with you further on. And also what activities and how long they will be working in that country if they're not a citizen of the host country or have permanent residence in that host country. Now, many people have worked remotely abroad during the pandemic and intend to do so in the future. And people believe that as long as you can enter a particular country as a tourist, and that could be for 180 days, it could be 90 days, or it could be longer depending on the jurisdiction, you're able to work remotely in that jurisdiction. Unfortunately, that's a misconception. When entering as a tourist, your activities are incredibly limited. It's tourism, visiting friends or family, or very basic business activities. And doing your job remotely overseas and doing your day-to-day work can actually mean a breach of local immigration rules, which could lead to fines or potential imprisonment, depending on which jurisdiction you're working in. So as the employer, it's incredibly important to check where the nationality of the individual, where they intend to remotely work, and what activities they'll be conducting and how long they intend to work there. Many employers who have advertised that they are allowing employees to work remotely across the world without issue will have caveats to that. So they may say you can do it only for 10 days, 2 weeks, a month at the most, and they're taking a very risk-based approach, because remote working or entering a country as a visitor for a short period of time is unlikely to raise any real suspicion amongst the authorities, and they're taking a risk-based approach in allowing that to happen. But there's plenty more other than immigration to take into consideration. It's also, if you are allowing an individual you may employ in the UK, for example, who is subject to UK immigration conditions because they're in the UK under a work permit, and they decide they want to go home to the US, India, or wherever to work remotely for a time, what will that remote working mean for their UK immigration permission should they ever wish to return to the UK? If they're sponsored, so they have a work permit, because of the pandemic, the Home Office has exceptionally allowed an extended absence from the UK without the employer having to withdraw that sponsorship. But the longer they stay outside of the UK, it may call into question the genuineness of that role physically in the UK and whether sponsorship should continue to be appropriate. There are also updates that you'll need to make to the Home Office in respect of their working location. You'll need to maintain your sponsorship compliance duties in respect of contact details and so on. In respect of the EU settlement scheme, so post-Brexit end of the transition period, a number of EEA nationals living and working in the UK also decided to work from home. With the EU settlement scheme, it will lead to permanent residence known as settled status after 5 years continuous residence in the UK. Now that continuous residence is normally broken after a 6-month absence from the UK, unless it's COVID related. Now, if that person intended to return to the UK after a 6-month absence, they'll be able to continue on their pre-settled status. But when they come to their 5-year anniversary and to apply for settled status, they would have broken their continuity of residence, and they will no longer, unless the employer then agrees to sponsor them, which comes at significant additional cost. So that's another consideration when agreeing to any remote working, is if you intend for that person to return, what are the repercussions for their own immigration permission to live and work in the UK? Apologies, the slides are still not working. But we also thought we'll just mention sort of the EU and Irish immigration angle. So post-Brexit, British nationals have lost the right of freedom of movement. So if a British national wanted to work remotely in the EU, we would have to assess the member states' provisions to whether that would allow the remote working or not. However, British nationals can still work in the Republic of Ireland without any immigration issues, and vice versa. Irish nationals can live and work in the UK, and that's because of the common travel area and the relationship that Ireland had with the UK prior to the EU, prior to the EEA. So the common travel area has never been reliant on Ireland's membership of the EU. So that remote working is absolutely possible. And that's sort of a quick run through on the immigration side of things. And I will pass you on to my colleague, Rosie, to talk about the employment rights.
Thank you. So now I'm going to move on to talk about employment rights. As Colin mentioned, employees may acquire mandatory employment protections in the host country. And broadly speaking, these are the minimum statutory rights that all employees are entitled to in the country. And what they're entitled to will vary depending on the jurisdiction. Typically, it would include things like rights on dismissal, working hours and rest breaks, sick pay, health and safety protection. The point at which the employee acquires these rights will depend on the laws of the host country, but as a general rule, the longer that they're in the host country, the more likely they are to have acquired local protections. Just by way of example, so in the UK, when we're determining whether an employee has the right to claim for mandatory UK employment protections, the tribunal will look at whether the employee has a sufficiently close connection to the UK. And in doing that, it will look at all of the facts. So, for example, where the employee's home is, whether they have accommodation in the UK, where the employee pays tax and social security contributions, where their employer is based, where they're paid and what currency that's in, and also the choice of law in their employment contract, as well as anything that's been said to them about that. So whether an employee can claim local mandatory employment law protections will be a particularly important consideration for an employer if they're travelling to a country where the rights of employees are much more favourable than their home country. So, for example, if the employer wanted to dismiss an employee while they were working abroad, and the employee could turn around and say, I have local rights which entitle me to more protection from dismissal, a longer notice period, or even a termination payment, this could make dismissing them much more complicated and expensive for the employer. Another point to consider is whether time spent abroad will affect an employee's ability to participate in certain company benefits, as these could be affected by the time they spend abroad. So, for example, if they have private medical insurance under a group policy, this may not cover them while they're working abroad. And it may also affect their ability to pay pension contributions and receive tax relief on those contributions. If you're unsure about this, the best approach is usually just to contact your benefit providers and check the position. And then if there are any issues or changes, you should notify the employee and agree with them what's going to happen before they travel abroad. So in instances where an employee is working remotely for a significant period, it's important to consider how it might affect the rights that the employer more typically has under the employment contract. So, for example, if the employee is creating valuable intellectual property for you from an overseas location, is the assignment of rights that you have in your favour in their employment contract going to be sufficient, or are you going to need to get bespoke local advice? If the employee misuses your confidential information while they're abroad, do local laws give you a sufficient protection against this? And finally, if their employment contract contains post-termination restrictions, oh, we have slides. Oh, no, gone. Oh, there they are. If they have post-termination restrictions such as non-compete and non-solicitation clauses, will these still be fit for purpose if the future competitive threat is coming from abroad? So, two things to kind of really think about in this is if an employee has permanently relocated and does not plan on returning to the home country, obtaining an injunction in the home country may not be enough to deter them from breaching the restrictions while they're overseas. And secondly, the employee might also try and argue that you should bring enforcement action in the host country instead of the home country because this is where they now work. And if, say, that jurisdiction in question requires payment to enforce restrictive covenants, it may not regard English law governed covenants as being enforceable. This may be a reason, I think, to discuss later, to move an employee onto a local law contract with enforceable local covenants. Another point to consider is whether the employee's role involves processing personal data. It's important to consider whether this can be done in line with any data protection laws, and this will be a particularly important consideration where an individual will be processing special category personal data. So, for example, healthcare, criminal convictions, or anything relating to race or ethnicity. And that will include, for example, people that work in human resources. Even if the data can be transferred lawfully, it's always important to consider whether in practice you're able to keep that data secure while the employee is working abroad, as data breaches in themselves can pose a significant reputational risk. You should always consider asking your IT team to take a look at the equipment that the employee is proposing to using while they're abroad, just to ensure that that's properly protected and secured. And then the final point I wanted to mention was that in addition to legal considerations, it's also important to consider how the arrangement will work practically for your business. So if the employee is working from somewhere with a significant time difference, you should consider what hours you would actually like them to work in practice, as you may wish to have an overlap at least to some degree with their colleagues in the home country. The other question is, how will you ensure the employee is being adequately supervised and supported while they're working abroad? In some regulated sectors, it's necessary to show that particularly more junior employees are receiving adequate supervision, and this can be more challenging if they're based overseas. And then finally, some countries are still limiting travel and implementing lockdowns, so it's important to consider firstly how likely this is, and secondly what would happen in this scenario before you agree to the employee travelling. So now I'm going to hand over to Linda, who's going to take you through some of the options that are available to employers to minimise the risks of employees working remotely overseas.
Thanks, Rosie. You obviously have the magic touch in getting the slides to appear again, so I'm lucky to have them. If our invisible assistant in the background wouldn't mind moving on to the next one, please. I'm just going to touch on some of the practical tips. So Colin's going to talk a bit more about the things that you should include in your legal documents. I suppose one of the themes you'll probably see coming through everyone's little section today is that to bear in mind the longer the employee's abroad, the greater the potential risks are in terms of all the topics that we're talking about today. So it's quite important, particularly if they're going to be abroad, working remotely abroad for a long time, to take advice from local counsel in the country where they're proposing to work from. So on the topics we're talking about today, the tax, the social security, the immigration and the employment obligations. So I'd say that's particularly key if you're considering longer term arrangements for an employee. Like in my experience, very often employees themselves aren't fully aware of potential implications for them. So having some of that information up front could actually change their desire to relocate. So communication would be critical, and that's the main point I'm making here. If you're thinking about implementing a policy, there's definitely benefits to it. And one thing to consider is, are you going to have a policy for short-term requests and a policy for long-term requests? Is it all going to be one policy, or are short-term requests going to be dealt with on a more informal basis? So just being really clear about what the policy covers. And when you're putting it in place, you need to consider, is everyone equal when it comes to these requests? Or are there particular roles or categories of employee where for various operational reasons it just can't be considered? And that's particularly important before you start communicating out the policy more broadly. You should also have a think about whether the host countries will be considered equally for employee requests. There may be some countries that for operational, tax and regulatory reasons, it's absolutely not possible for you to facilitate those types of requests in. So really think about, is there any countries that can't be included in your policy? We're seeing a lot of client policies being put in place at the moment, but we have seen with some of our clients, there are certain countries that they are willing to facilitate these requests for because they've carried out specific due diligence on those jurisdictions, so they know exactly what the implications are. Also, we're seeing these requests being facilitated more easily where the employer already has a presence in the particular country, because that does make things a little bit more straightforward in most circumstances. So as I said, some of our clients have started to implement policies or maybe adapt older policies that they had that dealt with these types of requests to make them more fit for purpose. There's definitely benefits to putting a policy in place. So it does make sure that you have a standardized approach and that everyone is treated as equally as possible in terms of processing their requests. It also means that requests are centralized. And I think that's quite important because it does help you to keep a better handle on what requests are happening and what's being allowed, and also gives you better access to data about all the remote working arrangements you have around the globe. And that type of information can be invaluable. Of course, there are risks with putting a policy in place that you should think about, and those would be around whether the policy is potentially creating any indirect discrimination risks. So, for example, if the employer is based in the UK and you have a blanket no requests to a policy that says you won't accept any requests, do you risk employees who are not UK nationals claiming indirect discrimination based on their nationality because they are more likely to be making those requests, say, for example, to be closer to family or for family reasons? So those are things that you'd need to consider. And if that is the case, you'd have to consider whether you have any objective justification for that approach. So that might be issues around the fact that it would create additional cost or risk for the company in facilitating those requests. Or as we're seeing in some regulated environments, it's just actually not possible for the company to approve those requests because the regulator would be uncomfortable with certain key people working outside the jurisdiction. So those are all things to bear in mind. Colin's going to go into more detail on the legal arrangements and what you should document. But as a general approach, my view would be the longer term the arrangement is, the better it is to move them onto a local employment contract. And maybe for shorter arrangements, you could consider a short side letter. The reason to put them onto a local employment contract would be it gives you more confidence that you're actually complying with local requirements, and you can take your advice in that regard. But also, and as Rosie touched on, you can make sure that important clauses around IP, restrictive covenants and confidentiality are actually going to be enforceable and are fit for purpose for the new arrangements. big key point to remember as well, which often gets forgotten about, is insurance. It's really important to check any company insurance policies to make sure that you're not inadvertently invalidating those insurance policies by facilitating requests. So, for example, are you covered if an employee has your equipment in another country, or if the employee has a work-related accident in another country? Do your policies extend that far, or do you need to get extensions in order to facilitate the request? And just moving on then to the next slide, if we can, just really, it's just about focusing on the importance of communications and awareness. So you could have, and I think probably most people on the webinar will appreciate, you can have an absolutely brilliant policy that you've worked really hard on, but if it's not being followed by your people managers, it's not actually adding any value to your organization. So your people managers have to be aware and understand what your global mobility policy is, particularly around what is okay to consider and what is not okay to agree to, because you want to be careful they're not creating expectations that the company can't then follow through on with employee requests. It's really crucial as well that they know what the formal request process is and that they signpost employees making those requests to follow that process. And also give employees an indication of maybe even a checklist of the types of things that would be considered or what information they may need to move a request forward. And in my experience, that's pretty crucial in terms of trying to reduce the potential for people managers approving requests that ultimately HR or global mobility or finance or tax teams have to actually row back on. And we have seen this as a bit of a, I suppose, a side effect of COVID, where people have already relocated on a temporary basis and were given an expectation by their manager that that arrangement could continue permanently. And then when it came to the attention of, say, the relevant legal, tax or HR team, it couldn't be facilitated for various reasons, tax, regulatory reasons. And that creates a serious employee relations issue. So those employees have made a big life decision to move on foot of what their manager had indicated to them would be possible, and were very shocked and upset when that couldn't be facilitated. And in a lot of cases that we've seen, that's led to grievances that had to be resolved by the organisation. And in some cases, we have seen that lead to resignations where employees were particularly aggrieved or had actually physically moved on a permanent basis and needed to resign. I think we're probably going to see a lot of pressure on people managers to facilitate these types of requests, particularly as part of the war on talent and the pressure to keep talent in an organisation. I understand that we're expecting what's being called a big resignation following COVID, where a lot of employees have soul searched and decided where they want to carry out their roles and the type of roles they want. So I do think people managers will be under pressure to facilitate these requests. So it's really key that they're armed with the right information about what the organisation's approach is to it. And just one final point that I wanted to make, and I think it's a query we get a lot, is around monitoring employees. It is important to try and keep an eye on where employees are so that risks aren't being created inadvertently. But just be careful how you go about this. We have seen situations where employee laptop locations were used to prove that they weren't in a country where they said they were. And that may be okay, depending on what your privacy policy says and what your disciplinary policies say. But in certain circumstances, we've seen that that wasn't clear from the employer privacy policy and ultimately led to complaints. So just to be careful that if you are monitoring location, you're fully covered under your data protection policies and your privacy policy. So those are some of the practical issues I wanted to flag, and I think it's back over to Colin now to take you through some of the legal considerations.
Thanks, Linda. If we can go on to the next slide. So looking at what to agree with the employer, and then picking up on Linda's comments, what this section isn't about is those circumstances where you decide that actually what we need to do here is move the employee onto a complete permanent new employment contract in the location to which they have relocated, nor is it looking at other sorts of intercompany agreements that you might put in place if, for example, you decide that we've already got a company in place in the host location and we could do some sort of secondment arrangement or something like that. Rather, this is focused on what we might agree as a side letter with an employee in circumstances where the underlying deal is that we're keeping them on their home country employment contract, but we're agreeing particular additional provisions that will apply for the duration of the period that we've decided that they can be in the host country. One sort of I've heard the sort of slightly heretical comments that, you know, perhaps if it is for a really short period of time, your sort of classic 2-week holiday tag on or something like that, and you're doing it on the basis that we're taking a risk-based view here and turning a bit of a blind eye to the employee's decision to work from an overseas location. You know, do we actually want to put in place a paper trail around that at all, or would we be better off just keeping stum? And that is something I think that you have to think about. But I think, you know, in most circumstances, it is helpful to put in place a letter agreement with an employee which sets out a few key principles that you've agreed for the duration of their period outside their home country. As to what that might include, well, it's obviously going to vary from case to case, depending on the individual circumstances and the particular circumstances of the jurisdiction that they've gone to. But here are some of the things that you might think about and look to include. First of all, whether to make the employee liable for any additional income taxes or social security arising from the relocation, with perhaps some right for the employer to make deductions or seek reimbursements if they need to do so. It may be said, well, surely we can't just pass on an employer social security contribution that we're obliged to pay in a particular jurisdiction to the employee. If that's our liability, it's our liability. Is there anything we can realistically do about that? And that's right up to a point. You can't contract out of your obligation as a general rule as an employer to pay particular taxes or contributions that are your due, but that doesn't stop you agreeing to make contractual adjustments with the employee if you've been left out of pocket by their decision to relocate overseas, and that might be done in various different ways. For example, just an adjustment to a lower salary in the event that an additional cost is incurred for a period of time. That's something you could look at. It sort of echoes here of the sort of tax equalisation clauses we've seen in expatriate agreements for a long time, long before the current trend for overseas working. Secondly, employee to be responsible for any additional personal tax declarations they might need to make in the country they've gone to. I think that's fairly basic. A statement that the employment contract remains subject to the law and jurisdiction of the home country. And again, back to the point about the possibility of the employee acquiring mandatory employment protection rights that Rosie talked about. While this isn't going to be an absolute defence everywhere, it will be helpful if you've documented the fact that you continue to remain subject to your home country contract and home country laws continue to apply. But then query also, particularly if this is intended to be a longer term arrangement, or possibly one that you're open-minded about becoming permanent at some future point, whether you might reserve the right to ask the employee to move on to a local contract at some point. Important question: who is the employee still working for? In all likelihood, the answer is going to be they're still working solely for the business in the home country, and indeed there may be tax and possible permanent establishment concerns if that isn't the case. But again, going back to the point that if you have got an entity in the host country already, would it be appropriate for them, for ease of administration, to have some sort of relationship with that entity, even if it's just limited to things like them processing payroll, if that's helpful for a limited period of time, or administering certain benefits. And then critically, a date that the employee is expected to return from the host country, so lay down the expectations on that, and very often you'll want to write on reasonable notice to require them to return home should you direct them to do so. I can go on to the next slide, please. So what else might you agree? Well, this is with a view again to reducing that permanent establishment risk where that's a particular consideration. So things like making it clear that the employee doesn't have any authority to enter into contracts with local customers while they're in the host country, and shouldn't hold themselves out as having that authority, those being key red flag issues from a permanent establishment perspective. Should we get the employee to acknowledge, where appropriate, that they won't have the right to certain benefits while they're abroad? I think the most obvious one there is probably the private medical insurance policy. To the extent that they benefit from that, you might want to make clear that if they want to have that sort of cover, it's up to them to arrange that at their own cost. But there may be others as well, and that's something that you will need to check on a case-by-case basis, depending on the benefit schemes that you have in place. Employees to make sure that they have the right technology and arrangements in place to work effectively, including appropriate security, again with an eye to the sort of confidentiality and data privacy issues that Rosie touched on earlier. That could be particularly important. It's important anywhere that an employee is working remotely, but perhaps all the more so where they're working in a different jurisdiction. And again, that echoes again of the position we see domestically. If there are going to be additional costs that are going to be incurred as a result of that arrangement, who's going to pick up the bill for that? Is it going to be the employee, or is it going to be you? The employee working from home at their own risk, and the employer not liable for any loss that they incur as a result of their home working arrangement. Now, that may or may not be enforceable depending on health and safety rules in the jurisdiction that they've gone to, but that may nevertheless be a marker that you want to lay down. And finally, and importantly, particularly in the ongoing pandemic situation that we live in, the employee to comply with all applicable public health guidance, both in their home country and the host country, and that includes, of course, any quarantine requirements that apply to them, which you may expect them to follow. So that's what you might want to think about if you're putting in place a side letter or other agreements to sit alongside the employment contract with the employee. If we could just move on to the next slide, and in fact our final topic before we wrap things up and open things up for the Q&A, there's the question of whether you should use an employer of record or a professional employer organisation, as they're sometimes called. Now, there's been an undoubted upsurge in availability of these services and usage of them by employers in the last 18 months or so. And for those of you who aren't familiar with them, I mean, the basic proposition that's offered to you is that we come along and we solve all of the problems that both of us at the panel have spent the last 45 minutes talking to you about. So in other words, we take on the formal responsibility for employing your employee while overseas and accounting for all of the tax and social security and other administrative requirements that you need to have in place, and we supply that person to you. It is, I mean, in UK domestic terms, it's an employment business setup where somebody else employs an individual and supplies that person to you, but it operates on a cross-border basis. And they're increasing in popularity, and they certainly have their role. We work with a number of clients who are using them effectively in appropriate cases. But I think it is important to go into them with your eyes wide open, and in particular look at the detail of the commercial arrangement. What is the deal that you're being offered here? To state the obvious, there's going to be a cost attached to this, because how these organisations make their money is by charging you a fee in return for their services. But what are you getting in return for that, and how much risk is the third party organisation taking on? In particular, if things go wrong, they fail to account to the relevant local authorities for income tax and social security withholding, or pay the right contributions, or if the labour inspector comes after you because you haven't made the right registrations, are they accepting all cost and risk that comes from that with an appropriate indemnity in place, or are they looking to pass that on to you? I regard that as fairly basic. I think that's certainly something that they should be covering, but sometimes once these terms and conditions where these things aren't clearly addressed. But will they go further than that? What about employment claims for the individual in question? If you are sued in the local employment tribunal or labour court, is that something that the employer of record is going to take on for you, or are they going to put you in a position where they say, well, sorry, that's your look at, because whatever the contract says, in reality they work for you, and we all know that, and that's your liability, in which case you could be back in the sort of the alien world of an overseas jurisdiction whose laws you know little about, and having to navigate your way through that system. So that's something that you would want to be careful about. And there are more fundamental questions, such as whether the organisation has done its due diligence on whether this type of arrangement is even permitted in the jurisdiction in question, and whether they have the right licences in place. It is a lot of jurisdictions, particularly in Western Europe, have quite strict laws on illegal lending of labour, and if you take on and supply somebody to a third party without the requisite employment agency licences in place and so on, you could be running quite a degree of risk, which ultimately could, depending on local laws, sit with you as the end user. And final thoughts to think about are, okay, this person is no longer, at least from a legal and contractual perspective, your employee. Do you nevertheless have enough ability to control the way they work and work with them on a day-to-day basis in the way that you would want to? And how do things fit, such as confidential information and IP and restrictive covenants. If the latter is important, so you want to have enforceable non-competes and non-solicitation clauses with the employee in question that apply once their employment comes to an end, does that really work with an employer of record arrangement where you don't have a direct contractual relationship with the individual in question? That's something you would need to look at with the benefit of advice from local council where appropriate. So as I say, these are arrangements which I think have their place, but go into them with your eyes wide open and make sure that you're clear on what the deal is that you're being offered, how much risk is covered, and how much exposure there might still be, notwithstanding the arrangement that's been put in place. I think we have managed, and I think it's back over to John, because I think we've managed to finish bang on 10 to 5, just as we were looking to do, in order to allow 10 minutes for questions. So John, I think we're handing back to you at this point.
Many thanks, Colin, and to everybody else for your insight on this important topic. Apologies again to everyone that the slide deck wasn't working for part of the presentation. There appeared to be some gremlins in the system which we eventually fixed, but rest assured a copy of all the slides will be sent to you along with a recording of the session later this week, so you will be able to take your time going through them again separately. Turning to the Q&A portion of the session, the first question we have from the audience is a bit of a two-parter. So, is there a short period of time that an employee can spend abroad where the tax and employment law risks are low, for example, 2 to 4 weeks? And is an employer required to register employees working in certain jurisdictions with a local labour authority? If so, again, is there a certain period of time before they have to do this?
Okay. Well, should we take those in reverse? Because I think the sort of the second question is probably for me and Rosie, and the first question is perhaps for us with some input from Victoria as well. I mean, the answer to the second question is yes, in some countries there will be, and that goes back to the mandatory employment laws of the country in question, and whether in that particular country there is an obligation whenever you're employing someone to register with an external labour authority. In some countries there is, in some countries there isn't, and that's always something you would need to look at on a case-by-case basis. And that really does highlight the fact that obviously one of the big difficulties in advising in this in this area is the fact that there are 200 different jurisdictions in the world, and depending on where your employee has chosen to go to, different rules may apply. But that is something that you would want to be wise to. We go back to the first question. Well, actually, Victoria, why don't you come in on this first, then as DP, Rosie and I can chip in further.
I mean, from a tax perspective, as I said, basically the longer the employee spends in a country, the greater the risk. And so I would be relatively relaxed if somebody, from a tax perspective, if somebody was spending 2 to 4 weeks there, provided it's not, part of a more substantial period of presence. But again, it does depend on local laws. I can't give you a carte blanche, but the risk is likely to be relatively low.
Yeah, and I would add that I mean, this is the most commonly asked question, and I would love it if we could give a simple response to it. But the reality is that there isn't a sort of cut-off point beyond which you can say, well, up to this is fine, and beyond this you may have problems. But what I would say is, certainly in my experience, in terms of my own client base, I think more and more organisations are taking a pretty pragmatic approach to this, and taking the view that if something is anything in that sort of 2 to 4 week range, pretty unlikely, it's pretty low risk that we'll run into problems with that. So that is something that we might become comfortable with. And I think particularly in the context of summer holidays in 2021, and people looking to tack on a couple of weeks from their parents' home or their family holiday villa or something, I think that's something that we're seeing more and more organisations regard as acceptable. But yeah, it's not a hard and fast rule. Not nice though it would be if there was one.
Next question. If an employee wants to argue that remote working abroad would benefit their mental health and well-being, how risky is it for a business to deny such a request? And do you have any advice on how to monitor the mental health of employees while they're working abroad?
Linda, do you want to take that one, and then I'll chip in?
I suppose they'd want to have, certainly from the Irish perspective, I think they'd want to show some serious medical evidence as to why the remote working abroad is so crucial in terms of any mental health issues they have. I mean, certainly I would love to be able to do it for my mental health regularly as well. So I think that's probably, it's not just even about remote working. That probably comes into questions around, remote working abroad, remote working at home, facilitation of any mental health issues that the employee may have that requires reasonable adjustments or reasonable accommodations in the workplace. So if that did come up and the organisation didn't have a policy around facilitating these requests, I'd certainly be looking further into what are the background reasons for this. Is there another way that we can accommodate this, or is it essential before I'd make any decisions around that?
Yeah, I would echo what Linda has to say, and I agree that I don't know that there's any qualitative difference between a request to work from home in your own country and a request to work from home abroad here. I mean, it's all in a broader question of, what are the underlying reasons for wanting to work remotely, and what is the mental health issue? Do we have a proper understanding of that, and in what way is this going to assist with that? And I think that's the approach that you would need to take, and assess what evidence there is, and if there is some clear evidence that this would help the employee's mental health in some way, then that's something you may be required to agree as a reasonable adjustment. But if that isn't the case, it's something you can potentially push back on.
Yeah, and I think looking at, is this a temporary request or is it a permanent request, all of that would be relevant as well. It might be something that an organisation is comfortable to facilitate on a very short-term basis because of a specific period of difficulty in an employee's life.
Okay, and finally, I believe this was touched on earlier, but just for those who may have joined the session a bit late and missed it, what considerations are there where an employee wants to work half the year in one jurisdiction, half the year in another? And does the answer to that question change if the reason for the request is for parental status?
Well, I think the issues with that are probably everything we've been covering in this session, really. I mean, I suppose there's a sort of wide question there. If we're saying we've got an employee who wants to work 6 months in one country and 6 months in another country, and the first question is, are we as an employer okay with that? Is that something we want to facilitate? Because obviously an important starting point with all of this is whether we might just want to say no to that. But if we do want to facilitate it, it would be a question of looking at all of the issues that we've covered in this session and then working out what was the best arrangement to put in place to support that. I mean, if it was literally a sort of 6 month split, I mean, I wonder whether it's a sort of circumstance where a sort of dual employment contract in two countries might be the sort of thing that's fit for purpose. But I think you would really need to work through all of the tax and immigration and employment law issues that we've covered throughout the session, and sort of get a good sense of what the risks are going to be and how you might best manage them and go from there. I don't know if anyone else wants to add anything to that.
Well, I'm pleased to say that actually the other questions we've had in have all actually been definitely answered with your presentation. So, and that's good. It's just about much we've got time for today. So, my thanks again to the team at Lewis Silkin for taking time to be with us today, and to all of you joining this session. Just a reminder, the webinar has been recorded, and we'll be sharing the recording and the slides online in the coming days. Thank you for joining us, and we hope you get another IEL webinar again soon. Take care and goodbye.